CJ, sorry.
Thank you. Senior Counsel, what would you consider to be the role of presiding judges and heads of station across the country what would you consider to be the main challenges they face? Because they are the decentralized leadership out there, and what solutions would Senior Counsel offer as Chief Justice?
Thank you very much. And Madam Chair, may I ask for the liberty of referring to everyone as Commissioner and then their name, to shorten the titles?
Yes, we can.
So, Commissioner Mwilu, thank you very much for the question. I appreciate it. And I am grateful that I was given the opportunity in the last few minutes to explain my role as the DPP. There weren't very many state counsel in the Department of Public Prosecution, so I give you a number, 50. Today there are hundreds. But in the context of your question, my role during the time I was DPP is identical in some shape or form to the responsibilities of a presiding judge. You are the head of a unit or a department or a group out in the provinces, and you are in charge of all matters that arise. You are in charge of ensuring their output. You are in charge of discipline at the first level, taking complaints and making inquiries. And you are in charge of ensuring they stay motivated. They stay motivated. And in your, the judiciary, and I should call it ours for the purposes of this interview, in the, the current state of that is, of course, ensure performance as far as the performance management outputs are concerned. Insofar as problems are concerned, the problems that I have described for the DPP are no different from the problems that existed at some point for presiding judges. But today's problems, to me, appear different. Today's problems indicate a situation where today, meaning there is no Chief Justice, and I say yesterday, and when I say yesterday, I mean it figuratively, perhaps in the tenure of the previous Chief Justice. I have discerned from a memoranda that was submitted by the KMJA that to some extent there was a bit of a disconnect between the administration of the immediate past Chief Justice and the presiding judges in some of the work they were doing. So my solution, if I were honored to be appointed the Chief Justice, is to be a Chief Justice who, to use another description for leadership, a walk-around leadership style, where you spend a lot of time visiting your colleagues in the divisions, in the counties, in the magistrates' courts. I think I would spend far more time visiting them, listening to their problems, of course accompanied by the appropriate team of administrators, so that some of their problems are attended to as quickly as possible. Because I think in many cases it's a question of communicating the problem and somebody responsible enough hearing the problem. That's my solution, Madam Commissioner.
Senior Counsel, did you say that the situation is different now because we do not have a Chief Justice?
I said, as long as it is not a Chief Justice, the situation may not change. And I am not saying that the acting Chief Justice is not doing her best. I am simply saying it is not the same as having a Chief Justice, because the Chief Justice ultimately is responsible. Anyone in an acting position does not really, is also acting for a temporary time. So you don't start anything that you can't finish.
Is it Senior Counsel's considered opinion that then for these last 4, now almost 5 months, there's been a vacuum in the judiciary?
It is not an opinion, it is a fact. There is no substantive Chief Justice in office.
No, the question is vacuum. Has there been a vacuum?
I have not done a survey to ascertain what it is that would be described as a vacuum. I will only say I go by what is current and available to me, and I go by what I have read very carefully in the memorandum of the KMJA. So they are not concerned, they're not dealing with your performance as an acting Chief Justice. They are talking about the past administration, and they are talking about what they hope for in a future administration of the office of the Chief Justice. So I wouldn't want to pass any judgment on your performance as acting Chief Justice for the last 4 months.
Let's close that particular discussion on asking about the limitations to the execution of duty of an acting Chief Justice.
I beg your pardon?
What are the limitations, if there are any, known to you about the execution of duty of an acting Chief Justice?
I think the law is quite clear, the Constitution is quite clear. The acting Chief Justice shall do as much as they can while awaiting the appointment of a substantive Chief Justice. So the limitations are found in the word acting. Acting. When I say acting, it means exactly what it is. When you run an institution and your term is based on awaiting the appointment of a substantive holder of the office, every single person in that office views you through a certain lens. You are temporary in that office. For example, if you took a decision that in some way affects them, there would be the expectation that if the process was not concluded by the time there was a new Chief Justice, that decision could be reviewed. So what I'm trying to say is, and it is meant with no disrespect to you in your performance, I'm talking about what I know to be the outlook of any public servant when dealing with an officer who is holding office in an acting capacity.
Thank you, Senior Counsel. Had you not raised that question, we wouldn't have discussed it. But the more substantial question is, in your considered opinion, what you think an acting anyone is limited from doing. I want to suggest that your view, which you are 100% entitled to, is yours. Mine is completely different, and I think the law abhors a vacuum. There cannot be a vacuum, and I am not aware that the acts of an acting director, Chief Justice, would be reviewed on account of having been executed during the period of acting. But let's go to more substantial things. And the next one is this. This institution is run, at least since 2011, on certain systems with certain leadership positions and management tools that help the institution to achieve its core mandate, which is to make access to justice available to all Kenyans. Please tell us some of those systems that are already in place in the institution and how Senior Counsel, as Chief Justice, would either enhance or strengthen them, or what alternatives Senior Counsel Chief Justice Murgor would employ.
If I became Chief Justice?
If you became Chief Justice.
Thank you. I start, first of all, by recognizing the great work that has been done in transformation. It's unimaginable. As I explained earlier, I was there at the beginning. Perhaps I was interacting with the judiciary long before many in this room. So I know the wonderful work that has been done in the area of transformation. And I take this opportunity to salute Chief Justice Emeritus Willie Mutunga in that regard. First of all, on his vision. It's truly revolutionary. I also congratulate immediate past retired Chief Justice Maraga for the work he did in sustaining some of those transformation measures. So, and maybe I should go on to say, and the entire team of existing judicial officers who today, Madam and Commissioner Mwilu, are led by you. Plenty has been done. Plenty has been done. Now, you ask me what I would do to improve it.
The first part of the question is the systems already in place, and then what you would do as Chief Justice to either improve the existing systems or your own systems that you as my Lord Chief Justice would then develop.
I am going on, and I was developing it, what I would do, and I need to then identify what is the problem that it would then require me to do anything. In an ideal and optimum situation, which is what it is not, if I were to have come in such a situation, I would simply ride on the train and let the systems run themselves. But the situation is not optimum. The situation is not ideal. There is a huge challenge. There is a huge challenge. For example, on the issue of capacity, which affects access to justice, it is greatly affected by the staffing issue. The staffing issue, and in particular, I'm not talking about the 40, 50% to bring up the judiciary staff to 9,000. I'm talking about the judges that need to be appointed. And then I'm talking about the funding issues, which would then enable rollouts of ICT and everything else, and recruitment. That is the challenge. So I'm not coming into a situation or a job in order to carry on and improve. I'm talking about a situation where the ship of the, if I may liken it to a ship, merely, the ship of, that is the judiciary, which is a huge organization now, far larger than it ever was, is slowing down. It's grinding to some sort of halt. So it's not a question of improving, it's a question of what can I do, or what will I do to ensure that the system doesn't stop altogether? I was thinking about this problem, and I likened the problem facing the judiciary to the recent massive container ship that got stuck in the Suez Canal. It was called Ever Given. Modern ship, the best captain, obviously, all the technology in the world, sailing down the Suez Canal, and somehow something went wrong, something small. Lost control, the ship turned to one side and got stuck in the canal. It caused a huge pileup of traffic on both sides, a slowdown in world trade. For those who had to go around the Cape in South Africa, higher costs, slower delivery of services. From where I sit as an advocate, I can see that for the last 1 year, there has been a slowdown in the delivery of services to the public. And that problem has featured in every conversation for the last 1 year. It is on account of the failure to appoint a certain number of judges, cutback in budget. And Madam Commissioner Mwilu, please permit me now to explain what I would do. I consider those two as the causes of that slowdown. I consider that as the thing that, or the issue that has to be dealt with as a priority by any incoming Chief Justice. I sit here on this chair today
If there's one thing that all soaps do, it's wash. From buckets to basins, bathrooms to streams, and everything in between.
All soaps wash.
Yes, but Protex is different. Its reinvented formula with flaxseed oil boosts your skin's natural anti-germ defenses by 10 times more, protecting you against 99.9% of germs. So what keeps us healthy?
Protex.
Protex. Good health starts here.
Make is the bribes.
Get 500 MB free kila siku and never miss a moment.
Introducing Ushindi Cream Bar Soap. Ushindi Cream Bar Soap with Oxy Bright removes stains effortlessly and brightens colors. Available in 1 kilogram and 800 gram bars and 175 gram tablets. Also available in all your favorite variants. Ushindi, a quality product from Pwani Oils.
Wow, thank you for your time.
And do you have any question for us?
How juicy.
Juicy. Juicy. Niko fiti maze maze niko fiti majamana mabenti wako fiti. Juicy fruit, juicy fruit, juicy fruit, juicy fruit. It's made a lot richer, thicker, tastier. Only when life goes mosmos, it's a lot tastier.
carefree mom. You want the best for your child.
Happy birthday.
You make sure she knows the joy of sharing happy moments with family. And when everything comes together, you above all others will share the taste of success with her. Blue Band tastes like mama's love.
Just one capful of Dettol is enough to disinfect surfaces and protect your family and your home. Dettol, tested effective against COVID-19.
From the background of legal practice, and knowing as I do that you are forever in these courts, please tell us the challenges you have faced will lead you to regulating, making what rules for the effective enabling the institution of the judiciary to effectively make it possible for Kenyans to access justice and for the legal practice to effortlessly earn their keep.
Madam Commissioner, first of all, perhaps you will allow me to finish my answer. Because it also dovetails into exactly what you are asking me. So the problems of the judiciary today that require outside intervention is, in simple terms, a different approach. As the old saying goes, when you're in a hole, stop digging. The other saying goes, don't do something in the same way all the time, months in, months out, and hope for a different result. So, solve the problem of capacity, the appointment of judges, solve the problem of the funding, and the ship will continue moving, justice will continue flowing, and who knows, you don't need outsiders like us coming to tell you what to do. As for the rules and rules made by the Chief Justice, there is absolutely nothing wrong with the existing rules, and where necessary, the relevant committees will look at them, having taken feedback from all other affected agencies, court users, bar bench, and those are framed and finally promulgated following an agreement and consensus on what is required. So I personally, as a practitioner, have no problem with rules at all.
Thank you, Counsel. Thank you, Senior Counsel. Let's go to a different area now that I have to cover within the time given to me, which is this. Counsel, listen to this. Senior Counsel, listen to what I'm just about to read. Judicial power to nullify a law duly passed by the representative process is a restriction upon the power of the majority to govern the country. And I'll take that again. Judicial power to nullify a law duly passed by the representative process is a restriction upon the power of the majority to govern the country. Briefly and with guided answers, would Counsel kindly discuss that?
That really is the power of judicial review. And that power exists in our courts. And I'm not sure there is anything more I can say to that. The courts have the power to review some executive actions. In addition to that, the courts have power to declare certain legislation unconstitutional, declare certain actions by the executive unconstitutional.
All right.
And it is in itself, as you say in your question, the power to check the excess of those who at a certain point of time might be in the majority. So it protects the rights of minorities and those who may not have the power to legislate for their protection.
Thank you, Senior Counsel. In your opinion, is there a contradiction between the mandate of the institution of the judiciary under the constitutional framework and the principles of judicial restraint?
Please come again.
I'll take it again. In your opinion, Senior Counsel, is there a contradiction between the mandate of the judiciary under our constitutional framework and the principles of judicial restraint?
I'm not sure that I quite get your question. A contradiction between the judiciary and the principles of judicial...
We are told that the Constitution has told us what we must do.
We are told that the
Constitution... the Constitution itself has told us,
yes,
has given us our roles in Chapter 10.
Yes.
Out there, then we are told, and therefore the judiciary must continue to discharge its duties to the best of its knowledge and ability under Chapter 10 of the Constitution. You will hear that the judiciary must exercise restraint. In fact, if I left it there and I said discuss, what would Senior Counsel say?
You know, you make it sound, Commissioner Mwilu, like we are in an exam. But my answer, my short answer, is, and I suppose we are, or you are alluding to the subject of judicial activism and its limits, or what are its perceived limits, whether it is desirable or not. But my short answer is this. I don't know who has told you when you say we are told, but I'll take it that that is a criticism that has been leveled at the judiciary by some quarters. For my part...
Senior Counsel, if you live in this country, you have heard those statements all the time. That the judiciary is doing things that are not theirs, they should not annul laws, they must not... Remember, we are covering a certain topic. They must not legislate from the bar, they must from the bench, etc. There must not be activists, they must exercise restraint. That is as simple as I can make it, Senior Counsel.
You know, perhaps I'll answer it by answering a question that I had expected Madam Chair to ask me for, as I started. What is my judicial philosophy? Then that way I will give you an answer that stands in a certain position.
That is the topic that we are covering right now. That actually is my area.
Madam, I will answer your question in the way that I see fit. So
okay.
Please give me a bit of time. So I believe there are two philosophies on either side of a spectrum. There is the progressive and there is the conservative. And then in the middle, there is what I would call the moderate philosophy. I belong to the moderate philosophy. So in answer to your question, too much of either side is not good. Too much conservatism, too much progressive interpretation is not good. In the positive spectrum, a judge supplants his personal, political, or other views on his interpretation of the law, and you get a situation where you start at point A and you end up so far away that when you look at the section or the article that is under consideration, you can't recognize it. So, to the phrase, there should be judicial restraint, I subscribe, in the sense that one must limit themselves to the limits provided under the Constitution. Now, when you look at our constitution, as it has been described, it is very progressive. And if it is progressive, many of the articles allow for a purposive, for example, a purposive interpretation. It gives the judge some leeway in interpreting that section. The phrase or the criticism that you refer to as judicial restraint is simply a comment that can be made by a party that feels aggrieved by that decision, that even as you interpret an article, you should exercise judicial restraint. You can go so far, but don't go too far. So that is my short answer.
Senior Counsel, I thank you. Let us go still under the same topic to the Constitution. Emeritus Chief Justice Mutunga once said this, which I quote, "It is unusual for a constitution to be as preoccupied by the question, scope, methodology of its own interpretation as Kenya's 2010 Constitution." I'll read that again. "It is unusual for a constitution to be as preoccupied by the question, scope, methodology of its own interpretation as Kenya's 2010 Constitution." Now, Senior Counsel, as I had interactions, I hope I should have actually started there, with the Supreme Court's decisions, particularly those concerned with constitutional interpretation. And now this is a question. What are your views on the court's position, the Supreme Court's position, on constitutional interpretation? The second limb of the question, distinguish for us, please, what you consider to be the methods and objectives of constitutional interpretation, and whether it is possible to generate progressive and contextual jurisprudence utilizing the tools of strict constitutional interpretation. Are we still together?
You've lost me. I'm not sure even you are with the question.
Yes, I am.
Please repeat it.
I am with the question because I'm the person asking the question. It took me time to come up with the question.
Okay.
So I know the question. And it is this. And it exercised the mind of Chief Justice Mutunga as it exercises mine today, and as it has exercised the minds of many counsel in this country when they discuss the work of the Supreme Court. Chief Justice Mutunga was of the view that the 2010 Constitution was so subjected to discussion as to its scope, the methodology of explaining itself, explaining as into interpreting it. And so, I ask, part of the criticism the court has received is that it does not know what it does when it is interpreting the Constitution. And here we are looking for your views.
As to whether or not they know what they're doing.
That, and whether or not there's a difference between there are many ways of interpreting the Constitution as the Supreme Court currently, as constituted, understood its role, and as any interpretation it has applied to the Constitution been restrictive to creating jurisprudence. I hope now you understand.
I will try and answer your question as I understand it. I first deal with the Constitution. There are those who have studied the type of Constitution we have, and as much as it is described as the most progressive Constitution and the
Please discuss a few of the policy issues that we have discussed in our 2019-2023 strategic plan.
I'm sorry, madam. Your question is not specific enough for me to answer it. Maybe I should put it this way.
Have you interacted with the 2019-2023?
All the challenges that the country is facing today, a lot of rationalization needs to be done. You need to relook at the planning aspects of all the development projects and rationalize them so that rather than having 62 courts that are incomplete, rather than having ICT projects that are in the pilot stage, stuck in a few courts, rationalize them so that you are able to complete a few projects. And the one that has the biggest impact on access to justice, on the delivery of the core mandate, which is justice, is developing, rolling out, fully covering the country with ICT capability in every respect, from end to end.
All right.
Yes. So if you tell me to run with something, I would run with that.
All right. Thank you, Senior Counsel. I said my final question will be on the court at which you would be president if God were to grant that you be the Chief Justice. That court has had occasion to deal with certain cases, a number of them, to enable our initial vision of being the court that has promoted alternative dispute resolution mechanisms. Would you like to discuss one or two of those cases and tell us what the decisions were?
The decision that has
enhanced alternative dispute resolution mechanisms, or even discussed the issue of alternative dispute resolution?
The one that comes to my mind is U2. The one that under discussion is the one that
I could actually mention two of them.
Yes.
One is Synergy, a famous case, and the other one is New2.
Yes.
There is a line of them there. But could you then tell us, those two, what was their import? What were they concerned about? How have they helped us to be better at promoting alternative dispute resolutions?
U2's decision is the one I had in mind. And I'm grateful you ask, because I am also an arbitrator, and I also undertake and also conduct arbitrations. It was quite disturbing in the manner that the string of decisions had gone to create a situation where there was no longer any certainty about finality of arbitration decisions. So U2 put that back in good stead, that the whole idea, not U2 actually, I actually should say that I'm in agreement with the decision of the retired Chief Justice, that there should be a finality in the decisions.
In Newton?
No, it's the other one.
No, it wasn't Newton, but thank you very much, Senior Counsel. That will be the end of our discussion, and I wish you well.
Thank you very much.
Thank you, Chair. Sorry, thank you, Chair.
Thank you, Commissioner Acting CJ. I would like to now ask Honorable Commissioner